concussion-related lawsuit could influence future insurance policies for NFL players. A lawsuit by a concussion-plagued former NFL player who is suing his insurance company after being thwarted in his attempt to collect on a policy for a career-ending injury could shape how such policies deal in the future with brain injuries suffered by football players, experts said. Haruki Nakamura, a safety who played 5 seasons for the Baltimore Ravens and Carolina Panthers, filed the lawsuit last Monday in North Carolina after Lloyd's of London and its underwriters denied his bid to collect on his $1 million policy, according to the lawsuit. Nakamura, 30, suffered what his lawsuit calls a career-ending concussion while playing for the Panthers in a preseason game against the Pittsburgh Steelers in August 2013. I think it has the potential to be very significant with respect to how players are able to secure these policies and how the insurers treat these policies on the front end, said Gabriel Feldman, the director of the sports law program at Tulane University. It presents a lot of different scenarios for actuarial calculations and risk management. It threatens another avenue for NFL players to be able to protect themselves as it becomes increasingly clear that playing football presents some level of risk to the brain over time for a growing number of players. Players are recognizing that risk and some are retiring earlier. Some are taking other precautions. Chris Borland has no regrets about his decision to retire early from the NFL over concussion-related issues. Nakamura's attorney, John Schreiber, said the case represents the first time that he has dealt with an insurer that refused to pay where the team, the NFL and an independent medical examiner have all agreed that the player's injury is career-ending. Schreiber, a DC-based partner at the firm Reed Smith whose insurance recovery practice includes recovering for professional athletes under their disability policies, said that might be due to the nature of the condition, post-concussion syndrome. Our prior cases, where we have recovered without resort to litigation, were for injuries other than concussions, Schreiber said via email. He said that concussions may become the leading career-ending injury for football players, adding that for a disability insurer to deny coverage for damage caused by a concussion would be like the issuer of a homeowner's policy denying coverage for damage caused by a fire. Nakamura is seeking $3 million, triple the value of his insurance policy against a career-ending injury, in the lawsuit to cover damages, costs, attorney fees and interest. According to the lawsuit, Nakamura suffered a hit to the head while making a tackle during the August 29, 2013, exhibition game. He was removed from the game and diagnosed with a concussion. Nakamura was placed on the injured reserve list and was released by the Panthers with a settlement due to concussion, according to the lawsuit. The lawsuit says that Nakamura's post-concussion symptoms worsened in the following weeks and months and he experienced headaches, impaired cognition, visual changes, fatigue, depression, and suicidal ideation. Specialist Michael Collins of the University of Pittsburgh Medical Center determined Nakamura to be permanently disabled due to post-concussion syndrome with the likelihood of no hope of improvement sufficient to return to football, the lawsuit says. According to the lawsuit, in late 2015 the retirement board of the Bert Bell Petruzzel NFL Player Retirement Plan awarded Nakamura total and permanent disability benefits based on neurological findings that he was totally and permanently disabled due to chronic post-concussion syndrome. But Nakamura was unable to collect on his insurance policy for a career-ending injury, with the lawsuit saying that insurance underwriters subjected Nakamura to voluminous paperwork and delays while investigating and then denying his claim. Nakamura was not allowed to have an advocate accompany him to an examination by a medical expert selected by the insurer, according to the lawsuit, and the insurance underwriters denied the claim based on the findings of that examination.